Hi everyone. We're just going to give it a few more minutes for everyone to join, so we'll get things going at 11 a.m. Um, so sit tight, and we'll get things underway shortly. Okay, hi everyone. Let's make a start. So, welcome to our webinar today as part of our Employment Essentials series, where we're looking at the basics of recruitment and onboarding compliance. My name is Simon Obee. I'm the head of HR advisory here at Employment Hero, and I'm joined by Neith Sockham, who is the HR advisory manager. So, before we get into the details of what we're going to be talking about today, just a couple of housekeeping points. We will go for an hour, and we'll try and keep to that time frame. The webinar is being recorded, and you'll be sent a copy of the recording after the webinar's finished, and we will also be circulating copies of the slides. If you have any questions as we go through, you can use the Q&A function. If there's time at the end, we might be able to answer some questions then, but if not, we'll go through all the questions that have been answered, been asked, and put an FAQ sort of document together. So please do ask anything that you'd like to. Just by way of a disclaimer, the information that we're providing today is general in nature. And if you need advice on your own individual circumstances, we'd encourage you to seek professional advice. The HR advisory service is there for exactly that. So do reach out to us if you do need help with anything in your business. So, what are we going to talk about today? We're going to look at job ads, targeted recruitment, reasonable adjustments for disabled job applicants, interview integrity, what you can and can't ask in interviews, pre-employment checks, giving references safely, and then Neith is going to talk about withdrawing job offers, compliant onboarding, privacy and candidate data protection, and a bit of a case study at the end. And we'll also tell you a bit more about HR Advisory and Employment Hero at the end of the webinar. All right, so let's jump in. Oh, we're going to start with the poll just to get a bit of a pulse check on how people are feeling about recruitment and onboarding. So how confident are you that your current recruitment and onboarding processes are fully compliant with the law? Very confident. We have clear processes and regular checks in place. Somewhat confident. We do our best, but there may be gaps. Not very confident at all. Compliance is a bit of a grey area for us, or sorry, not very confident or not confident at all. We're unsure where to start. So have a answer to that. It'll be interesting to see what people say. Here we go. So have a look at that. I hope you can see that on your screen. That's good news. There's only 1% who said not confident at all, only 3% that said not very confident, but most people are somewhat confident, 76%, and 20% are very confident. So hopefully by the end of the webinar, we'll have a few more in the very confident camp. But thank you for filling that in. That's really interesting information for us. All right, let us now jump into a bit more of the detail. So we're going to start off with job adverts and the law. So how does the law impact job advertising? Well, The first thing to bear in mind is it is an offence under the Australian consumer law to mislead employees or job applicants regarding their employment. So the Australian consumer law, you might not think that has anything to do with employment from its title, but it definitely does. And it makes it very important that job adverts and just any information that is supplied to candidates through the recruitment process is honest and accurate. So particularly that applies to job adverts, but could also be things that is said in an interview or any information that is provided to candidates. There is an offence for misleading people in this area, and on the right hand of the screen you'll see a few examples from case law where employees have been able to bring actions in damages, and they were all awarded compensation because their employer misled them in the recruitment phase. So the first case, Morton and Interpro, the employee was promised as part of the application process that their bonus would be calculated using a particular formula. However, when they started, the company changed its position on that, and the employee was able to successfully sue their employer. Moss and Low Hunt and Partners, the employee was given misleading information about the company's financial status. In other words, the employer sort of overinflated how well the company was performing, and the employee was able to bring a action for misleading conduct there. And then lastly, O'Neill and Medical Benefits Fund of Australia. In this case, the employee was given assurances about the long-term nature of the role they were applying for and how they would have great job security for a long period of time. But as it transpired, they were made redundant within 2 years, and then they were able to successfully sue their employer. I think the point to bear in mind here is not every case where an employee is made redundant within the early stages of their employment is going to mean they were misled. It is only where the employer knowingly says something false or has no reasonable basis for making a statement that a potential breach will arise. So in the O'Neill case, it would have been that the employer said something that they knew was not true about the likely length of employment, etc. So it's only going to be in edge cases that these sorts of things will arise, but really important that you are taking care about the statements you make. The second thing I wanted to highlight in terms of kind of compliance and job ads is there has been quite a recent change made to the law as part of the closing loopholes reforms that you might recall, which came in over the last couple of years. And that makes it an offence for an employer to advertise pay rates in a job ad below those that are required by law, in other words, below the relevant minimum wage. So if you are putting out job ads which talk about rates of pay, even either an hourly rate of pay or a salary, it is really important that you've put your mind to the question of whether those pay rates are sufficient, bearing in mind the relevant minimum wage. As you will hopefully know, that the majority of employees in Australia are covered by a modern award, which sets out minimum wages on an industry or occupational basis. So it is important that you put your mind to, well, does an award apply to this role, and what is the relevant minimum wage before you publicise pay rates. You can imagine how awful it would be that before you've even employed someone, you get penalised for breaching that obligation. And then lastly, do be aware of discriminatory language in job ads. As you will, I'm sure, be aware, employment law makes it unlawful to discriminate against people on the basis of various protected characteristics, race, age, disability, gender, etc. So It still surprises me how many job ads you see where it says something like we're looking for a young, energetic salesperson. Putting words such as young in a job ad is clearly discriminatory, and be aware of making job roles with gendered titles, waitress, stewardess, chairman, that kind of thing, obviously discriminatory too, and could get you into some hot water. So just be aware of that. Okay, sticking with the discrimination law and what that means in the employment context. As I've said, it is generally unlawful to discriminate in recruitment by treating people differently on the basis of protected characteristics, but the law does allow for preferential treatment, different treatment in a couple of different circumstances. So one of those is targeted recruitment, or sometimes referred to as positive discrimination. And the law says that it is possible to give preference to groups of people who are in underrepresented groups in the workforce, and that's what's called in law a special measure. So you see this quite commonly where preference is given to Aboriginal or Torres Strait Islander applicants. Either they are guaranteed a interview in the role if they apply, or perhaps there is a number of roles reserved for people of that background. It might also arise if you are a business who has, say, underrepresentation of females in leadership. That might be another way where you would use a special measure. And the law permits that in certain circumstances. The other way where discriminating on the basis of a protected characteristic is sometimes allowed is where the nature of the role means that it is a genuine occupational requirement of the role to have someone of a protected characteristic. So, for example, selecting an actor on the basis of age or race or sex for authenticity purposes, or considering only women job applicants for a role that involves body searches of other women, or employing persons of a particular religion to teach in a school established for students of that religion. What's on the screen is a kind of general summary of how the law operates. Discrimination law is dealt with on a state and territory basis. So the law does vary between those states and territories. So if you are looking to use a special measure or a genuine occupational requirement in your recruitment process, a very good idea to get some professional advice. New South Wales, for example, you have to make an application to the relevant government department before using a special measure. So yeah, do reach out for some help in this area, because it can be quite complex, but hopefully that gives you a bit of an overview of how it generally works. Now, another area where it is allowed and in fact required to treat people differently on the basis of a protected characteristic is reasonable adjustments for disabled persons. So where you have a person with a disability applying for a role, you have a duty to consider whether there are any reasonable adjustments that can be made to support them in that application process. So that could involve things like allowing extra time for any pre-employment tests that you require them to do, allowing an application to be made verbally rather than in writing, allowing a support person to attend the interview with them perhaps, or changing the location of the interview to somewhere more easily accessible for someone with mobility issues, or it could be providing information in different formats, in Braille, in larger text, etc. And there will be a myriad more adjustments that can be made. Obviously, you have to assess these things on a case-by-case basis. The thing to remember here is that your duty to make reasonable adjustments in the recruitment process only extends insofar as those adjustments are going to be reasonable, and that will be impacted by the size of your organization, the resources you have available to you. But if making that adjustment would be too expensive or too disruptive to how you conduct your business, then it's not going to be a reasonable adjustment. But it is something that you need to think about, and think about, as I say, on a case-by-case basis. I think a top tip in this area is to make sure that as part of your recruitment process, either in the job ad itself or in information that you send out once people have applied for the role, is to ask candidates if they require any adjustment to the recruitment process, to get their suggestions, and that is going to put you on the front foot for making sure that you comply with your obligations in this area. Okay, so let's keep going. And we wanted to talk quickly about interview integrity, what you can and can't ask in job interviews. Now, I think this is an area where there is a bit of misinformation out there. When I've looked into this topic before, you see a lot of commentators saying, it's against the law to ask someone about their age or about their disabilities or about their religion. And the way that the law works is probably a little bit more nuanced than that. It's not generally the case that the law says you can't ask questions about these sorts of characteristics, but it is certainly high risk to do so unless it's essential for you to know this for a legitimate purpose. Because if you have obtained this information about a protected characteristic and it transpires that you don't offer that job applicant the role, it's very easy for them to assume and to make a claim that the reason that they weren't offered the role was because they revealed information about a protected characteristic, and that can be very difficult for you to defend. So the golden rule here is don't ask this information unless it's really relevant to the role. So, for example, you shouldn't ask someone about their age generally, but of course, if you are recruiting for a role where there is some legal requirement about age, perhaps you're recruiting a bar person and they need to be a certain age to serve liquor, that would be a reason to do that, of course. The other thing I would point out, it is often a good idea to make inquiries about whether someone has any mental or physical health issues, which is going to affect their ability to perform a role. It's perfectly lawful to ask questions about that, but it is much better to phrase those sorts of questions, making it clear that you're only interested in health issues that are relevant to the role that's being performed, rather than just an open question, do you have a disability? Because as I say, it is only where these health issues are relevant to the role that you should be collecting information about that. And we'll talk a bit more about pre-employment checks and health assessments in the next slide. So moving on to pre-employment checks, there are a number of checks which are either mandatory or are very good ideas for employers to perform. So the first check there on the top left, nationality and visa checks. This is something that you should be doing for any new recruit to make sure that you are acting compliantly. It is an offence under migration law to employ someone who does not have a right to work in Australia. Therefore, you need to ascertain that they are either a Australian or New Zealand citizen. If they are, then they automatically have work rights to work here. But if they are a citizen of another country, then you will need to check that they have a valid visa to work in Australia. As generally done through what's called a Vivo check, which is a check on the government's portal, which will provide information on their working rights. You can do that through the Employment Hare application, which seamlessly links to that, but you need to do that in all cases. Reference checks are obviously a good idea, speaking to former or current employers of a job applicant to make sure that the information they've given about their work experience is accurate and that there are no flags. And that is obviously something which a lot of businesses do. The compliance point to bear in mind with reference checks is you are very likely to be breaching your privacy obligations if you perform reference checks without first getting the individual's consent. So make sure as part of your recruitment process that you are seeking their consent before reaching out to any referees. Criminal record checks are becoming more and more popular, it would seem. But the compliance issue to be aware of here is that it's unlawful to discriminate on the basis of irrelevant criminal records. So if you are performing criminal record checks and you are then making decisions on hiring someone on the basis of those checks and what they disclose, it's important that you've put your mind to, is the record that has been disclosed to me relevant to the role that is being performed? So, for example, if you're recruiting someone in a finance role and a criminal record check reveals a driving offence, it's probably unlikely that that is going to be relevant to the performance of their role, and so you'd risk discriminating on the basis of an irrelevant record if you made a decision on the basis of that. Contrast that with a situation where a offence relating to fraud or something like that is revealed. That probably is going to be relevant to someone working in finance. So you'll need to put your mind to that. Okay, restrictions that could stop the employee working for you, so post-employment restrictions or restraints of trade. This is something which you might want to think about, particularly for senior roles. In other words, is the person that is due to join you, is there anything in their existing employment contract with their existing employer that is going to stop them working for you, particularly if they are joining you from a competitor? There might be a restraint of trade that they've agreed to in their employment contract, which would affect their ability to join you. The last thing you want is, you've set everything up for them, they've joined the company, and then you get a letter from a lawyer threatening an injunction if you continue to employ them. So it is worth, particularly for those kind of senior roles, asking them direct questions about restraints of trade. You can get them to show you their employment contract if you need to, etc. And then medical checks. So following on from what we said on the previous slide, it is perfectly lawful and possible to ask job applicants to complete questionnaires about their health or to have medical assessments so you can see whether there is anything relevant in their medical history or their current condition that is going to be relevant to how they can perform the role. The thing to be aware of here is it is going to be unlawful not to employ someone on the basis of a disability, unless it means they can't perform the inherent requirements of their role, even with reasonable adjustments. So let's kind of unpick that a bit. Say you are recruiting for someone in a warehouse role, and the role involves lots of heavy lifting. If you did a medical assessment and a health issue with a physical health issue was revealed, which made it clear that they couldn't do any work that involved heavy lifting, that might well be a signal that they couldn't perform the inherent requirements of the job. You would need to think about whether there are any reasonable adjustments you can make to the work processes which would allow them to perform that role. But if it is something like a picking and packing role where day in, day out, all day, every day, they're lifting things, and that's a requirement, it might well be that there's no reasonable adjustments that you could make. It would then be lawful not to employ that person on the basis that they couldn't perform the inherent requirements of a role, and there would be no reasonable adjustments you could make to change that. Contrast that with a situation where the medical assessment reveals that the warehouse applicant has a mental health issue, perhaps depression or something like that. That's very unlikely to be something which means they can't perform the inherent requirements of a role, and so you would risk a discrimination claim if you decline them on that basis. Obviously, if you're looking at this sort of thing, a good idea to get professional advice, and what we said about reasonable adjustments on the previous slide apply. It can be a change to a process. It can be getting someone specialist equipment to help them in their role, but again, it is only reasonable if in terms of cost and disruption to the business, etc. Okay, finally, other checks that might be required are those that might be required by law. So things like working with children check might be a statutory requirement. So have a think about that if you are in an industry where that's going to be relevant. A couple of top tips here. We think it's a good idea to include something in your employment contract whereby the employee has promised or given a warranty that the information they have provided to you in the recruitment process is accurate, and you could have a statement in there saying that if it transpires that it wasn't accurate, that you can terminate employment, just to give you the best possible chance of being able to deal with a situation like that in any way you want to, if it unfortunately turns out that way. And lastly, of course, make it clear that the acceptance of any job offer is dependent on successful pre-employment checks being performed. Now, lastly, from me, I just wanted to talk about giving references safely, because this is something that a lot of businesses ask us questions about. So here we're talking about where someone approaches you about one of your employees or a former employee, and they're asking for you to give a reference. Well, what does the law say around this, and how can you make sure you're doing this safely and compliantly? Well, the first thing is you should always check that the individual has given you permission to provide a reference. Otherwise, you risk breaching your privacy obligation. The second thing you hear people say quite often, oh, it's illegal to give a bad reference. I'd say it's a little bit more nuanced than that. It is absolutely a requirement that any reference you give is honest and accurate, but If it is genuinely the case that you thought the employee wasn't performing well or didn't behave well, then as long as you have a reasonable basis for saying that, there is no law that prevents you from giving an unfavourable reference. Obviously, that can be a bit of a difficult path to tread, and businesses sometimes struggle with decisions about, well, should we give this person a reference? We gave this person one, but how do we make that judgment call? So some businesses will have an approach where they don't give references that comment on the suitability or the performance of someone at all, but they will limit themselves just to providing a statement of service, which will just include details like the start and end date, the job title and the duties performed, and maybe the reason for termination. Have a think about whether in your business it would make sense to have a policy whereby managers are told we only provide statements of service rather than detailed references. If you've made that clear to managers, if you've made that clear to existing employees, it can avoid those difficult conversations about whether a reference should be provided or not. So think about that approach if it is something that you struggle with. So that's it from me for the time being. I'm going to hand over to Neith to talk about withdrawing job offers.
Thank you so much for that, Simon. So let's shift gears a little bit and talk about potentially withdrawing an offer from someone that you've extended an offer to, right? So for many of our clients, it's not uncommon to encounter issues after you have found an ideal candidate and extended a job offer to them. But what happens if before their employment officially begins, circumstances change, as they often do from time to time, right? So, for example, reference checks may reveal information that calls into question whether a person is truly the right fit for the role that they have applied for, or a candidate might accept the position, but then they fail to commence work on the agreed start date, right? That's another scenario. And then another common scenario that we see is the person might repeatedly delay their start date due to an illness, perhaps, or care responsibilities or other personal commitments. And these situations can leave employers in essentially a limbo state where they're uncertain about, what their obligations are and what is the best way to move forward while still protecting their businesses from compliance risks. What happens if you decide that you no longer need the role to be filled, or you realize that the person you've offered the role to isn't the right fit for the role? Can you just pick up the phone and then say to them, "Sorry, I'll have to withdraw the offer," right? And as with many things in HR compliance, the answer to that question is not that simple. It's not a straightforward yes or no. It depends on a range of factors like why you're seeking to withdraw the offer and when you're seeking to do so. So there's the timing and then there's the reason that you have to look at. So in this particular part of the webinar, I'm going to unpack the ins and outs of withdrawing a job offer. So when you can do it, how to do it in a way that creates the least amount of risk to your business, and what the potential consequences might be if you handle it in the wrong way, essentially. So as Simon mentioned before, from a consumer law perspective, which, as he said, counterintuitively also applies to employers and employees, if a candidate has been given the assurance that there's a vacancy available, when in fact there isn't, or perhaps you don't actually need the role, right? Making them an offer with that knowledge could amount to a misleading and deceptive practice in breach of Australian consumer law. So he's unpacked that for us already, right? And he's also unpacked some of the discrimination law issues that can arise in the context of recruitment as well. So what I'll seek to do now is to place all that knowledge that we've obtained in the context of withdrawing an offer from someone. So before withdrawing a job offer, again, just as a starting point, it's important to check your reasoning for withdrawing. So some of you might ask, well, why do I need to think so deeply about it? It's probably not that deep because that person is not an employee yet, right? And that's a perfectly valid question to ask. But it is important to remember that when it comes to laws relating to discrimination that Simon has outlined before, for instance, so like the state-based anti-discrimination law, even the federal ones, and even the general protections regime under the Fair Work Act, they apply not only to existing employees, they also apply to prospective employees as well. And prospective employee is just a fancy technical term for job applicants. All right. The general protections regime prohibits employers from taking any adverse action against employees, including prospective employees, because they've exercised or proposed to exercise a workplace right. So, in the context of a job applicant, perhaps they might have certain questions about the job itself, right? That would be an exercise of workplace right. They might ask about pay too, right? So, that's one aspect of the protection. The other aspect is the protection also extends to any adverse action taken because they have a protected attribute, such as being of a particular race, or adhering to a certain religion, or having some form of disability, which can be both physical disability and also mental disability as well. If an employer is found to be in breach of these protections, it can result in a range of orders being made against them. That includes reinstatement. It can also include compensation for economic loss, but also compensation for hurt, distress, and humiliation as well. So you've got to keep that in mind because the consequences can be pretty severe. In addition to the general protections regime, and I'm just going to do this to quickly recap what Simon said, we also have the state and territory-based discrimination laws. And as you would have heard from Simon, these laws operate a little bit differently from the general protections regime, but the idea is the same, right? They protect employees, including prospective employees, from discrimination in a workplace context. So, with this understanding of the protections that are at play when it comes to employees and prospective employees, the questions that many employers face is when is it actually safe to withdraw an offer? And the answer is it depends. It depends on a myriad of factors, actually. And the answer doesn't just hinge upon timing, although timing is one factor to consider. And I'll illustrate with a simple example to begin with, right? So let's say you have a candidate, so let's call them candidate A that you really like, and you go ahead and make them an offer. And this candidate takes 3 days to consider that offer, right? And then during that consideration period, during that time, another candidate comes along. So let's call them candidate B. And they come along with really great skills and experience that more closely align with the role that you're seeking to fill, right? More so than candidate A, the person that you've extended the original offer to, right? In this case, you can revoke the offer to candidate A within that consideration period and make an offer to candidate B instead. And this is a simple scenario to tackle because candidate A has not accepted the offer that you've made. So you can revoke that, right? If you found someone with better alignment. So contrast that scenario with this one instead, right? This one is a little bit more complicated. Let's say you really like candidate A and you make an offer to them. During the period in which candidate A considers the offer, they then disclose to you that they have a medical condition. So let's keep it simple and let's say that they have chronic back pain that prevents them from lifting certain things of a certain weight. In this scenario, even though the candidate has not accepted the offer, which would typically establish an employment contract and that baseline employment relationship with you, it doesn't necessarily mean that it is safe for you to retract the offer, right? Doing so would trigger the discrimination protections that Simon and I spoke about earlier. And remember that they apply to prospective employees too. The only time when it is safe for an employer to retract the offer in this scenario is if and when they can establish one of two things, right? So the first one is there is a reason other than a discriminatory reason, so some other reason like they have better skills, right, for retracting that offer. So that's one thing that you can rely on, right? And the second one is a reason that applies if the reason for retracting the offer relates to the candidate's medical condition. So let's say if you want to retract it because they have the back pain, right? In that instance, you must be in a position to establish that because of that condition, the person is not able to fulfill the inherent requirements of their role, right? So in order to reach that decision, there's going to be some legwork involved, and you'll probably need to get them to submit to a medical examination so that a proper assessment of their capacity can be made. Another element to think about beyond all the discrimination issues that I just raised earlier, is what happens when an offer has already been made, right? And it has been accepted by the employee, right? Is an employment relationship established then? What are the implications when you revoke that offer, even though that offer has already been accepted, right? Are you just dismissing them in that instance, right? And this is something that employers need to carefully think about. And what I'll attempt to do is answer that question with a case illustration. So I'll go to the next slide, please, Simon, if you could for me. All right. So consider the case of Argentia and City Perfume Retail. And what I'll do is the information on the slides are there for you for your ease of reference and for your convenience as well. So I'll quickly go through sort of the key principles here, right, and the key facts. So in a nutshell, this is a case about a job candidate, Miss Argentier, who had accepted an offer. She signed the contract. She completed most of the onboarding documents and was then added to the employer's internal scheduling app and rostered to do her first shift. So just to be clear, she hasn't even done the first shift yet. She's just been rostered on to do the first shift and she's completed onboarding, right? So a few days later, the employer asked her to attend training before she commences her first shift, right? And the employer made it clear to her that the training was mandatory, but it would be unpaid, right? So when Miss Argentier refused to attend this unpaid but mandatory training, the employer immediately sent her a message withdrawing the job entirely from her, saying that, the job is no longer for you. The employer argued that that Ms. Argentier was never an employee. So naturally, Ms. Argentier was pretty irate about that. So she sued the employer. And what the Fair Work Commission found was that an employment relationship had already existed from the time that Ms. Argentier signed the contract and at the time that the employer integrated her into the business system, right? And the evidence that the Fair Work Commission looked at was things like the contract itself, which obviously created that baseline employment relationship, the fact that Ms. Argentier completed her onboarding. There was a receipt of communications, employment-related communications between Ms. Argentier and the employer. And there was also a clause in that contract which restricted Ms. Argentier from working for other people, right? And this clause is not anything that is super unique. You see a clause like this in a lot of standard employment contracts, right? It's probably something that they didn't even think about, right? So the lesson here is once you formalize the contract and start integrating the person into your workforce, even before they actually commence working the first shift, they are likely to be an employee, and any attempt to pull the rug out, so to speak, even before the official start date, can amount to a termination on the employer's initiative or can amount to a dismissal for the purposes of the Fair Work Act. This finding has two implications for employers, and these are the lessons that we can take away from this case, right? So the first lesson is you need to be careful about revoking offers. Thinking that you have revoked an offer when you've actually terminated an employee puts you on the back foot, and you might be exposed to various termination-related claims, as was the case here with Ms. Argentier. She made a dismissal-related general protections claim, and on a jurisdictional argument, she actually was able to succeed in the argument that she was dismissed. Second, you might be required to provide notice for termination. If you don't want to provide notice, you also have the option of paying in lieu of notice. And on this point, I just want to spend a little bit of time talking about it because it's a little bit of a gray area. So the question of whether notice is required when an employment relationship has been established, but the employee hasn't commenced employment yet can be quite a contentious area. So on one hand, there's this argument that if you haven't started working yet, then there's no employment relationship, right? That's the sort of conventional, simplistic understanding of it. But on the other hand, as we have seen with the case that I spoke about earlier with Ms. Argentier, an employment relationship can be found to exist by a court or tribunal even before the employee commences working. And the view out of the two that presents the lowest compliance risk to many businesses is the latter, right? And therefore, the conservative approach would be to give your employee the appropriate amount of notice if you seek to terminate their employment, at the same time making sure that your reasoning around termination is not in breach of any of the laws that Simon spoke about, like the the Australian consumer law, as well as the anti-discrimination laws. Next slide, please, Simon. The decision to withdraw a job offer is inherently risky, as it can quickly transition from a recruitment decision into a legal dispute. When this difficult situation arises, your priority must be to pause, first of all, right? I think that's an important point that we need to make, to just pause and then conduct a critical risk-based assessment before taking any action. To safely navigate this process, I recommend a 4-point inquiry, which involves asking the following questions. Just next slide, please, Simon. So the first question is, am I confident that my decision and reasoning around revoking an offer doesn't breach any laws, such as anti-discrimination laws? The second question is, if the answer is no to the above, are there any specific legally recognized exceptions that I can invoke? So, for example, in the case of physical and mental disabilities, can we invoke the inherent requirements defense or the reasonable adjustments defense that Simon spoke about, right? Remember, we might need to do some legwork before we can establish any of these defenses. Third, am I actually revoking an offer? An offer can only be revoked or withdrawn if it hasn't been accepted. If the candidate has signed the contract, or if they have completed substantial onboarding steps, they have essentially already accepted that offer and they might already be an employee, or at the very least, they might have an employment relationship established already. Fourth, if you determine that you are not revoking an offer, but are instead dismissing an employee who hasn't commenced work, you have to ask, have I given them the required amount of notice to terminate their employment? And this will require you to comply with the notice period specified in the signed contract, or if the contract is silent on this matter, then with the applicable national employment standards or award provisions with respect to termination. Failure to provide the correct notice or payment in lieu of notice can give rise to claims for breach of contract or the applicable modern award term or even the Fair Work Act itself. When you can confidently answer yes to all of the above questions, then revoking an offer may be safe. But if there is any doubt, and I'm sure doubt often arises when you're faced with a situation like this, because it can get pretty complicated, we strongly recommend that you hold off and pause once again and seek professional advice before taking any further action. And of course, the HR advisory team would be more than happy to help you navigate the situation. Next slide, please, Simon. So now let's move on to a slightly different subject matter, still related, still about onboarding. So now you have someone that you think is a good fit for the role. How do you get them ready for their first day and set them up for success from the get-go? Once your recruitment process is complete and offer is accepted, the focus then shifts to robust onboarding compliance. This stage is really important for giving some, I guess, meat and bones, so to speak, to a brand new employment relationship. And the key mantra to follow here is to set clear expectations from the start. So how do we do that? First things first, we need to ensure that the new employee receives the relevant Fair Work Information Statement if they haven't been issued one already. This is a mandatory requirement under the Fair Work Act. It's not just a nice to have document. The specific statement you issue depends on the employee's engagement type. All new employees must receive the standard Fair Work Information Statement, but if they are a casual employee, they must also receive a separate casual employment information statement. If they are an employee who is engaged for a specified period or a specified task or a specified season, they must also receive the fixed term contract information statement as well, which addresses the new limitations on the length and renewal of fixed term contracts. Failure to provide the correct relevant statements before or as soon as practicable after the person starts employment constitutes a breach of the Fair Work Act. Additionally, you also need to make sure that you have a copy of the fully executed employment contract if you don't have it already. So please make sure that you have it. A legally binding employment relationship is underpinned by a fully signed contract. It's not enough for the employer to simply just send the contract. You need to ensure that the employee has actually signed it and returned an executed copy to you. A fully executed contract is your primary defense against future disputes regarding terms and conditions, obligations, duties, wages, etc., etc. Without an executed copy, there would be ambiguity about the agreed terms, which can be particularly problematic when dealing with entitlements that differ from the relevant award or national employment standards. You should also ensure that a fully executed copy is returned to the employee as well for their own record keeping, just to close off the administrative loop. A critical aspect of setting the right tone as well is to make sure that you provide and clarify workplace policies with the employee at the start. These policies are more than just paperwork. They define expected behavior, rights, and responsibilities within the workplace, and employees should be formally provided with access to, and ideally an acknowledgement of receipt and understanding of the key policies that exist that are in use within your organization. And this typically includes, but is not limited to, policies on discrimination, equal opportunity, bullying, harassment, grievance procedure, so on and so forth. Setting clear expectations around these matters from day one is vital for creating a respectful, lawful workplace culture. And if an employee later breaches a policy, having evidence that they have been explicitly informed of it and trained on that policy significantly strengthens your position in any disciplinary or termination processes. Finally, an onboarding process would not really be compliant without a thorough work health and safety induction. So I want to spend just a little bit of time talking about this because it is super, super important. This is a non-negotiable legal obligation under work health and safety legislation across Australia, where the employer has the primary duty to ensure the health and safety of workers so far as reasonably practicable. A properly run work health and safety induction is generally needed to meet this duty for new workers. And also, depending on the role that you're doing the onboarding for, there might be an explicit obligation under work health and safety regulations, so separate from the legislation itself, to provide specific induction training. So something like a construction role in New South Wales, for example. To be clear, work health and safety induction is not just about, showing them like the fire exit, even though it's part and parcel of that, right? But the induction process itself must be a comprehensive process that is tailored to the specific risks of the employee's role and the location or site that they will be working on. An incomplete or absent work health and safety induction can be viewed by a safety regulator like WorkSafe or Safe Work in New South Wales. You guys have it a little bit different. As a significant failure to meet your primary duty of care, leading to the issuance of things like an improvement notice or a prohibition notice, or in the most serious cases, criminal charges can be laid as well. And therefore, meticulously documenting work health and safety induction, including the date, the specific content covered, and the employee's signature acknowledging completion is absolutely essential. Now that we know what good onboarding looks like, I want to quickly go through an area that doesn't get too much attention, but is nonetheless super important. So during the recruitment process, it's normal to come into possession a lot of information and documents belonging to candidates that are sensitive and confidential in nature, which naturally gives rise to the need to think about your obligations around privacy and data protection. Throughout the entire hiring cycle, an employer collects and generates a substantial amount of personal information about applicants, including resumes, contact details, notes from interviews, referee reports, and background check results. The handling of this data is generally governed by the Australian privacy principles under the Privacy Act, but for clarity, this act typically applies to organizations with an annual turnover of more than $3 million, but it can still apply to smaller businesses with a lower turnover if certain conditions apply. So if you're in doubt, definitely get professional advice accordingly. While the Australian privacy principles have an employee records exemption, which applies to information about current or former employees, especially when it directly relates to their employment, this exemption does not cover information about unsuccessful job applicants. If the act applies to your organization, you will need to treat all personal data of unsuccessful candidates with full compliance to the Australian privacy principles. So the first major consideration is collection. Under the Australian privacy principles, you must only collect personal information in a lawful and fair way. Furthermore, you have an obligation to provide a clear privacy collection notice as close as possible to the time of collection, and that notice has to detail the items set out on the slides here for your perusal. Next slide, please, Simon. So once collected, the focus then shifts to data security and storage. You have an obligation to take reasonable steps to protect the personal information you hold from misuse, interference, loss, and unauthorized access, and as well as modification and disclosure. And this applies to both physical documents as well as electronic data, which will require you to implement robust measures to protect those things, right? Like encryption or password protection, and even restricted role-based access for HR staff and hiring managers. You need to also consider the retention and destruction of this data. And as a matter of best practice, you should consider retaining these records for a period that allows you to potentially defend against any potential legal claims, such as an anti-discrimination claim or a general protections claim, before you securely and permanently destroy them. If you wish to keep an unsuccessful candidate's details on file for potential future roles, you must explicitly seek their consent for this secondary purpose, as using their data for anything other than the primary purpose, which is to assess their suitability for a role, right? The original role that they applied for may constitute a breach of the APPs or the Australian privacy principles without their clear agreement. And adherence to these principles throughout the entire recruitment process is super important for compliance and maintaining the trust and confidence of job applicants. I know we don't have a lot of time left, but I'll just quickly go through a case study to help you sort of solidify your understanding of what we have learned so far today. So if I could have the next slide, please, Simon. So as we're approaching the end of the webinar, I want to leave with you a little case study that brings the lessons we've learned so far to life. And I'm going to bring up a case that relates to the difficulty of managing disability discrimination in a recruitment context. The details of that case are set out on the slide here for your convenience, but to cut a long story short, in the case of Chalker and Murray's Australia, Mr. Chalker applied for a coach driver role and was found to be temporarily unfit for the role by a pre-employment medical assessment after he had disclosed to the employer, to Murray's, that he had borderline personality disorder. The employer, Murray's, went on to withdraw the offer from him, citing that issue around that his temporary lack of fitness, as well as an allegation of dishonesty on his part because he had marked no to a question on the application form asking if he suffered from a medical condition that might affect his duties. And I want you to remember that part, right? Might affect his duties. Mr. Chalker then sued Murray's for breaches of the New South Wales anti-discrimination legislation, which went to the New South Wales Civil and Administrative Tribunal, also known as NCAT, and NCAT made two key findings. So the first one was Mr. Chalker had not been dishonest with his answer because he had a genuinely held belief that his condition did not have any effect on his ability to do his job, right? So there was no dishonesty there, right? And number two, the second finding was, although he had been temporarily unfit for the duties of the role that he applied for, it didn't mean that he couldn't fulfill the inherent requirements of his role in the longer term, right? So the core danger from a discrimination law standpoint, and I suppose the key lesson here from this case is failure to properly assess whether a candidate is able to fulfill the inherent requirements of a particular role is fraught with danger. The tribunal found that the employer had failed to conduct further inquiries to properly determine if he could perform the essential task of the job he applied for in the longer term, right? So in short, basically what I'm trying to say is the tribunal had found that there was clearly not enough evidence for the employer to sensibly reach the conclusion that Mr. Chalker couldn't fulfill the inherent requirements of his role because of his borderline personality disorder diagnosis. So the takeaway here from all of this, because I know there was a lot of information here, is an employer should not be reaching any firm conclusions about a person's ability to perform the inherent requirements of a role without conducting a thorough medical examination. If retracting an offer is on the cards, an employer must be able to prove with evidence like a comprehensive medical report that a candidate cannot perform the genuine core requirements of the role, even with reasonable adjustments made for them. So that's it from me. I will hand it back over to Simon to have a quick chat about a special feature that Employment Hero has that might actually help you with your recruitment.
Thanks, Neith. Great stuff. So yeah, just to finish off, we've been talking about recruitment today. So we thought we'd mention quickly the Smart Match feature in the employment application, Employment Hero application. So this is a recruitment tool. It uses AI technology. When you put in the details of a role you are recruiting for, it will instantaneously go through the thousands of candidates in the system looking for work, and will create a shortlist for you of suitable candidates. So it is very, very quick, and saves a lot of time on what can be a very time-consuming recruitment process. It obviously also doesn't involve the costs of posting a job ad on a job board, or using an external recruiter. We've had loads of success with Smart Match. So if you haven't tried it yet and you are recruiting for roles, do check it out, because it is a really fantastic feature of the Employment Hero application. The other thing I wanted to mention briefly about Employment Hero is our HR advisory service. This is the part of the business where Neith and I work. And it's available either through the Employment Hero operating system or as a standalone subscription. For our HR advisory customers, they get access to unlimited HR and employment law advice. We've got a great team of advisors working with us who are experts in this field. We'll also perform a compliance health check when you come on board, looking at things like modern award coverage. You'll get access to every type of HR template you would need: employment contracts, policies, letters, etc. And if an employee brings a claim against you, you'll be given representation in that claim up to a certain point in the case. So if you do need some extra help with HR matters, yeah, we're really proud of the HR advisory service we have built. So look, we're bang on 12 o'clock, so I think we won't have time for questions today, but fear not, we will compile the list of questions that you have submitted as we've been going through. I've seen lots pop up, and we will put together a document, a kind of FAQ document dealing with those. So it just remains for me to say thank you to Neith, and thank you for everyone for tuning in, and have a great rest of your day. And if you need assistance with any of the stuff you've heard of today, or you want to hear more about Employment Hero, do get in touch, and we will speak to you soon. Cheers.